and welcome to a Newsflash episode of Unpacking the Case, the podcast by Davitt Jones Bould, the real estate law specialist. As always, I'm joined by our head of legal training, Richard Snape.
Hello, Richard.
Hello, Lizzie. How are you? Just back from London, I hear.
I am. I'm fresh off the train from London, ready to record some podcasts. And the first of which is a Court of Appeal decision from the 21st of January, so last week as we're speaking. And it's called Cloisters Business Centre Management Company Limited and Anvari, and it's about service charge statutory controls under the 85 Landlord and Tenant Act for mixed business residential premises. So can you tell us about it? What's the background of this one?
Yeah, it's Anvari and Wolf. There's a second person involved. Yeah, the Cloisters Business Centre Business Centre is in Battersea in London. It's a place called Priory House, and it's a former Victorian convent, hence the name. And one of it's various units, but one of the units, Unit 6, which is on the top floor, was the subject matter of the case. It consisted of a suite of rooms, but included a kitchen and a shower room. The lease was entered into, it's backdated. It started on September the 29th, Michaelmas Day on 1987, a 999-year lease. And the use of covenants allowed office use, but also ancillary residential use. Although at the time, at the moment, it seems that nobody's actually living there. It's been used for storage. There was that ability in the covenants. And to cut a long story short, the landlord was claiming that the tenants were with service charge arrears and wanted to bring action against them for the arrears. And the tenants argued that it's mixed business residential and it'll come within the 85 Landlord and Tenant Act. As you said, the 1985 Landlord and Tenant Act, an incredibly disjointed piece of legislation, but more on that shortly. Because if it does come within the 85 Act, then the landlord should have, the work must be reasonably incurred of a reasonable standard under Section 19 of the Act. And under Section 20 and the service charge consultation requirements, England regs, a fascinating read, they should have gone through consultation before they did qualifying works. They can't charge more than £250 per tenant unless they go through a consultation, unless they apply successfully to be exempted. So that was what it was about, and it went to the county court. The landlord claiming this money, and the tenants putting up this defence.
So what did the county court decide?
Well, the county court decided that the 85 Landlord and Tenant Act would apply to mixed business residential units, and it would apply here. And so they sent it to the first tier tribunal, who've got the jurisdiction to decide on service charge liability under the 85 Act, Section 27A. And then it was appealed. It was appealed to the Court of Appeal, and the Court of Appeal gave judgment on, as mentioned, January the 21st.
So what happened when it went to the Court of Appeal? What did they decide?
Well, they pointed out to start off with that the 85 Act is a mess. They didn't say that, but it's a consolidation of legislation. Background goes back to in terms of service charge and statutory control for residential properties. Went back to the Housing Finance Act of 1972. Then there was a 74 Housing Act which amended it, and the 1980 Housing Act that amended it, and then the 85 Landlord and Tenant Act consolidated and amended it. There was an 87 Landlord and Tenant Act that amended it, and so on and so forth, and it's about to be amended again when they finally get round to implementing the provisions in the Leasehold and Freehold Reform Act of 2024. So that's some of the background to it. And they also discuss, what Section 18 basically says when the provisions apply, this part of the Act applies, and they define a service charge as an amount payable by a tenant of a dwelling as part of or in addition to the rent. And under Section 38 of the 85 Act, a dwelling is defined as a building or part of a building occupied or intended to be occupied as a separate dwelling. So they basically looked at whether this particular suite of rooms would come within that. And they said that, they discussed a case called JLK Limited in Ezequiel as to whether it's a separate part of a building. Basically, that's a question of fact. It's physical condition of the building, if you like, and not what the user is. So in Ezequiel, it was in Liverpool, it was student accommodation, bed sits in a big converted property in Liverpool. And the students had their own little bed sits and the likes, but there was communal areas. And in Ezequiel, they said that, well, it doesn't have to be a home to be a dwelling. For one thing, it doesn't have to be your principal home or a home. It can still be a dwelling. But they said because there's communal areas, it's not, the individual units are not separate dwellings, so they didn't come within the 85 Act. But the court in this particular case said that they also looked at various other things, not least of which Section 32 of the 85 Landlord and Tenant Act, which says that certain parts of the Act deals with a lot of different areas, not really related on occasion, but certain parts of the Act, Section 32, made clear that leases within the 54 Landlord and Tenant Act would be exempt. They wouldn't come within the legislation. Things like sections 1 to 3A, which is all about tenants being able to request for dwellings details of the landlord from the person who collects the rent, and details of any directors if the landlord's a company, and also the landlord has to inform on assignments in sections 11 to 15, which deal with leases of less than 7 years duration of dwellings, where the landlord's responsible for the structure and exterior and the installations. But there was no such exemption mentioned in relation to sections 18 to 27A, which are the relevant provisions here. So by implication, the 54 Act leases would come within it. And if it's mixed business residential, it can come within the 54 Act. And they also said that it might not be occupied as a dwelling at the moment within the definitions, but it was intended to be occupied as a dwelling, which also fits within definitions. And for all of those reasons, it was held that mixed business residential properties, even if the residential element is ancillary and not being used, but can be intended to be used in the future, came within the 85 Act. It's quite an important case, very important case.
So why is it important, do you think?
Well, there's a lot of these things out there nowadays, Lizzie, and things like live-work units and the likes, much the flavour of the moment on occasion. And all of those premises would suddenly come within, if they've got service charge liability, any property which is mixed. You live on in a flat, there's a case Kensington and Chelsea and Melcraft a year and a half ago, where you've got a flat above your commercial, your office and the likes under a lease, and they'd all come, if there's a service charge liability, you come within quite stringent requirements for consultation before you can carry out works. You'd have to really think about it. And as I say, if they finally get round to implementing the relevant provisions in the Leasehold and Freehold Reform Act, there's going to be even more stringent provisions. It's amazing it's taken so long to actually have a clear case on it, actually. And that's it.
Well, thank you very much, Richard.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.